The Supreme Court has announced it will take up two landmark same-sex marriage cases early next year. The first involves California's Proposition 8, a measure that voters approved that recognizes marriage only between one man and one woman after the state had previously allowed gay couples to get married. Well, Prop 8 was struck down by a federal judge. This second case before the Supreme Court will examine the constitutionality of a federal law. The Defense of Marriage Act also defines marriage as only between one man and one woman. Let's bring in our experts before the justices get to it. We'll debate it here. Elizabeth Wydra, Chief Counsel for the Constitutional Accountability Center, and Brian Brown, President of the National Organization for Marriage. Welcome to you both.
Thank you, Shannon. Great to be here.
All right, Brian, I'll start with you. If some states and voters and legislatures have decided it's okay for people to get married, gay couples to get married in their states, why shouldn't the Supreme Court look at whether or not it's fair to ensure that those rights are recognized in all 50 states?
Well, actually, I'm happy that the court took the Perry case. The lower court, as you said, decided that the voters of California didn't matter and essentially threw out their votes, and did so in a pretty extreme decision, basically arguing that the majority of Californians, the majority of Americans who voted to protect marriage as the union of a man and a woman, are somehow motivated by animus and are discriminating. So I'm very happy, our organization is very happy that the Supreme Court took the Perry case. Proponents of same-sex marriage did not want them to take the case. They actually argued against the Supreme Court granting cert. So now the Supreme Court will decide, and I think it's time for the Supreme Court to correct some wrongs that happened, especially in the 9th District Court, which is, as you know, the most overturned court in the country. So we think that the Supreme Court is going to overturn the lower court decisions and is not going to create out of thin air a U.S. constitutional right to redefine marriage.
All right, Elizabeth, I want to bring you in here because along, of course, with the debate over Prop 8, there's the Defense of Marriage Act, which the administration decided last year it would no longer continue defending in these legal fights in court. That now is going to also be on the plate, a separate case. Where do you think we go with the DOMA case?
Well, I think that both cases really implicate core constitutional values of equal protection and freedom and the fundamental right to marry. And I think that I'm surprised that Brian seems to be suggesting that some of these most important constitutional rights can be put up to a vote. That's not how the Constitution works. And here we have the Equal Protection Clause guaranteeing equal protection of the laws to any person. And that broad language includes men and women, black or white, straight or gay. And it's not about expanding or creating out of thin air some new rights. It's about simply applying the plain text of the Constitution. And when federal judges have applied that plain text of the Constitution, they have found discriminatory marriage laws unconstitutional. And those judges they range from dyed-in-the-wool 9th Circuit liberals to George W. Bush appointed judges. So, you know, I think that I am confident that the Supreme Court, when they look at the Constitution, a majority of justices will find that these discriminatory marriage laws are unconstitutional, and rightly so.
All right, I want to bring in the latest Fox News polling that we have on this issue. Basically, when we asked folks back in, these are exit polls from November 6th, from the last election, of course, should same-sex marriage be legally recognized? Yes, 49%, no, 46%. Obviously, the country is closely divided on this, but we've seen a little bit of a shift in those numbers. Brian, do you think that the time has come that attitudes about this have changed and the court will go along with that change?
No, I don't think that's the case at all. I mean, look, 6 months ago, North Carolina voted by over 61% to protect marriage as the union of a man and a woman. Of course, there were the 4 deep blue liberal states that voted to redefine marriage, but that is an indication of the future of this country. There is no constitutional right to redefine marriage. Our founding fathers didn't see it that way, and the last Supreme Court decision, Baker v. Nelson, the United States Supreme Court said that there was no federal question here. So this is essentially making the law up as you go along. It is reading into the Constitution something is not there. And I do not believe the United States Supreme Court is going to launch another culture war. Just like Roe versus Wade did not end the abortion debate, creating a right to redefine marriage will not end this debate. It'll exacerbate it.
All right, Elizabeth, quickly, I want to give you the last word here, but you and I know that there are some really wonky things here before the court, issues of standing and what are the proper parties to be here. Do you think they resolve those and actually get to the merits of these two cases, or do you think we get hung up on something that stops short of making any real pronouncement on the constitutionality of gay marriage?
I think we won't really have a good sense of that until the oral arguments, which will probably happen in March, whether the justices are inclined to go with a sort of procedural out. But, you know, I think when you get back to the fundamental issue, you know, you don't have to read into the Constitution anything, like Brian said. You just have to read the Constitution. And the Constitution's plain text gives equal protection of the laws to any person. And that applies to same-sex couples just as it applies to opposite-sex couples. And I think that the Supreme Court, you know, they don't follow public opinion, but at the same time, I don't think they want to be on the wrong side of history. You look back 45 years when the Supreme Court struck down laws that forbid people of different races from marrying one another. And there you had, gosh, 73% of the country who thought that those laws were just fine. But the court said, you know what? We don't put our constitutional rights up to a popular vote. We apply the Constitution as it's written.
All right, Elizabeth Wydra, Brian Brown, we'll see where at least 5 of the justices come together on either one of these cases. Thank you both.
Thank you, Shannon.